Welcome to Leveraging Inspiration, the Inspired Patent Podcast, where we help you understand and leverage your intellectual property. I'm your host, Wayne Carroll, and I'm excited to bring you insights and stories from the successes and failures of others and teach you how to win at the game of intellectual property. I always start with a disclaimer. The information I provide on this podcast is for educational and informational purposes only. I am not providing legal advice, and nothing in this podcast should be construed as creating an attorney-client relationship. We're in week 3 of 13 weeks in this season. This is episode 10. This week we're talking about strong utility patents, and we're going to talk now about the drawings and what you need to know to avoid costly mistakes. Did you know that utility patent drawings can make or break your patent application? In fact, poor quality drawings can even lead to rejection by the patent office. So let's learn how to avoid those mistakes and make your patent application strong and successful. So the utility patent drawings play a crucial role in a patent application. They're there to help explain and illustrate the invention. So one of the requirements for filing or for properly filing a patent application is that it needs to explain how to make and use the invention. Now, the invention is what you're claiming in the claims. So whatever's in the claims, you have to show how to make and use it. And the Patent Office has interpreted that as it has to be shown in drawings, with a few limited exceptions, where if there's a laminate layer and you're describing it and it doesn't need a drawing to be understood, but in the vast majority of cases, the Patent Office considers that you need a drawing, especially if it's a mechanical device. If it has any mechanical parts in it, the Patent Office is going to say you need a drawing. So it's important to know what to include and not to include in your drawings and how to meet the Patent Office standards. And also, just kind of be a backstop for your attorney. Make sure that as you're reviewing things, some things to ask. So the first thing to know is that the drawings must support the claims. As I mentioned, it's the claims are what is the invention. It's actually a legal term, and we're going to talk about that in one of the episodes this week. So the Patent Office, they require line drawings for the most part. Now you can get away with images that are black and white. Those are hard to make work well. Oftentimes when we're patenting software, we do screenshots of the software, but we have to make sure those convert well to a black and white, and so that when they get uploaded to and we have to convert them to a black and white, and then they get uploaded to the Patent Office. Oftentimes, the Patent Office even downgrades the quality of it, and then that's what the examiner sees, and that's what's in the official record. So we have to, basically what their standard is it needs to be drawings that you can make a copy of a copy of a copy. Now, of course, we're doing everything digitally now, but that's still the standard, because it used to be you submitted paper drawings and they would make a copy of it, and they might have to make a copy of that copy. And if you are old enough to know what happened, each copy degrades. So so it needs to be line drawings, really clear lines, thick enough lines, and the drawings typically, they don't want a lot of words on the drawings. You can have a few words, but what they really prefer is numbering. So you point to each part with a number, and then in the specification, the written description, then you talk about what that numbered thing you're pointing to is. The next thing you need to know is as the inventor, you don't have to produce those drawings. Explaining what they are, partly because that can help you if you have drawings like that. So if you have CAD drawings, and you can provide that to your attorney, that can be helpful. But if you just have napkin drawings, you can send those to your attorney, and they can, as long as you can explain to your attorney and they understand what's going on, they can work on getting those drawings professionally done. So the drawings should not include specific measurements. A lot of times there are drawings that are your part of your manufacturing process that say exactly what part, exactly the size, exactly this and that. You can use those drawings, but delete all those specifics, because that can narrow your patent down too much by having those kind of details in your drawings. And one of the main things is you want to make sure that what is in the claims is supported by the drawings. That's really your patent attorney's job, but it's good for you to understand that that's a critical piece. What the drawings usually are is, so the goal is whatever needs to be discussed in the claims needs to be shown in the drawings. So sometimes there's cross-section views because you're showing the inside of a machine. Sometimes you need to have certain shadings to enhance understanding what different parts are, and your patent attorney should be able to get all that accomplished. The goal is to understand the invention and to show so that each part can be discussed, especially every part that's going to be in the claims. So there are patent cases where the drawings did not support the patent claims. One was in 1892 that went to the Supreme Court. So yes, 100 years ago, but it's still part of the history of patent law. There was an improved bedstead design, and it had a spring and a wire mesh support, but the drawings in the patent application showed a different design than the one that was in the claims. So the court invalidated the patent. It didn't just not infringe. They said this patent is not valid. They lost their patent rights after getting their patent and then fighting all the way up to the Supreme Court, and then they lost their patent. So another more recent example was with Arctic Cat v. Bombardier Recreational Products. This was in 2018 before the U.S. Court of Appeals for the Federal Circuit. That's the court that hears all the appeals that come out of the patent office. And in this case, and as well as appeals that are from, so any patent case that's appealed can go to the Federal Circuit. They basically specialize in patents. In this case, the patent in question was for a snowmobile suspension system, but the drawings in the patent application showed an alternative embodiment of the invention that did not include the claimed features. So this is another case where what was claimed wasn't in the drawings. Now, oftentimes the patent office, the patent examiner will say, you can't have those claims because you don't have it shown in the drawings. But apparently here, the attorney missed it, the patent office missed it, and so then that ended up invalidating the patent, and they lost their case. So you want to work with a skilled draftsman or patent illustrator. That might be someone that your patent attorney hires. And sometimes the drawings are simple enough that line drawings from CAD will be sufficient. And you want to provide detailed and accurate information about the invention to and your patent attorney may do that. So one thing to understand is that the drawing requirements are it's almost non-existent for a provisional patent application. And what can happen is, as I said, if the drawings don't support the claims, they can be invalidated. Now, with a provisional application, you're getting a filing date. What can happen is you can get a filing date with a provisional application. A year later, you file your non-provisional application, and you're still claiming that earlier filing date. And then you go forward and you get a patent. Well, if what was in those claims wasn't in that provisional patent application, and then later someone comes up with a publication that is in that year where between when you filed your provisional to your non-provisional, then they can use that to invalidate your patent. So your provisional application only supports to the degree it discloses and properly shows and discusses what is needed for your patent claims. So you don't want to put too many details in the drawings, but you want to make sure that the drawings and the specification discuss everything that's needed to support the claims you want. And so you want to make sure you have quality drawings, even in your provisional application. And so those are some of the important things with patent drawings. And our process, as this is what we recommend, is always we draft the claims first, so then we know what to put in to the drawings. If you put so much into the drawings and you're disclosing a whole bunch of things that you're not even claiming, then those embodiments you're basically giving away because you're disclosing them and you're making them public without getting patent rights to them. So you want your drawings to be crafted to support your claims. And to get strong patent rights and claims, we encourage you to book a call with us to discuss your patent strategy and get expert guidance on creating successful utility patents. Our next episode covers patent profanity and what you don't want in your written description.